Welcome to When Family Matters Become Legal Matters.
Welcome back to When Family Matters Become Legal Matters with Miss Betsy Holton, where we help you navigate the legal steps needed to protect your family, your future, and your legacy. Now, Betsy Holton is the founder of the Holton Law Group, who has years of experience guiding families through estate planning, elder law, and special needs planning. I'm Evan Mack, and today we're talking about how the way your assets are titled and how your beneficiaries are listed can completely change the outcome of your estate plan. Ms. Betsy, welcome back.
Hi, Evan. How are you? Good to be
I'm
back.
well. I'm well. Now, Miss Bessie, what's the difference between having estate planning documents and having a plan that actually works for you?
Yes, so that's the biggest question out there, right? Estate planning documents can consist of documents such as a trust or a will or powers of appointment, like a power of attorney, which we a lot of times call a financial power of attorney, or a designation of healthcare surrogate, which a lot of times we call a medical power of attorney. So those are just documents, just pieces of paper that say, this is what I have, this is what I'd like to have done with it, this is who I want to be in charge, both my finances and my medical, right? So they're just documents. They only work if the people that you've put in place know where to find your assets and what kind of decisions you would like to have made on your behalf, right? So that's what's so important about not just having documents, because yes, you could probably go online and just pull down some documents and you'll have documents. But if
Mhm.
you don't really understand what the documents mean, how they're going to affect your family, and how the people who are going to be placed in charge are going to be required to perform, then they're just pieces of paper that sometimes cause more conflict than they do resolution of issues.
Mm. What assets do people often assume are covered by their will, but really follow different rules?
Mhm. So, for instance, most financial accounts are what we call pay on death accounts, like your regular banking account, your checking and savings account. A lot of times, people re- don't remember to place a beneficiary's name on that account. And so, what ends up happening is even if you have a will, even if you have a trust, if you haven't named a beneficiary on those accounts, they are going to require you to go through a probate process where the judge appoints the person either that you named because you have the will or trust, or the person that the court appoints to be in charge of making sure that those assets are transferred. That's I really think it's a great asset and a great way to plan by making sure that you have beneficiaries on those accounts that mirror the language that you have in the trust. But that's not necessary. There are clients, and I have several of my clients that do this. They may have more than one banking or checking or savings account, and they have more than one child. And so they'll say child A gets the account ending in 123, child B gets the account that ends in 345. And so they make sure that when they go to the bank, that they list those children down as the beneficiaries of the account. So all that person has to do after the mom or the parent passes away is meet the requirements that the financial institution may have, which most times is just providing identification and a copy of the death certificate. Every once in a while, the bank may have slightly additional requirements, but for the most part, that's all that's going to be needed. However, if those beneficiary designations um, end up failing, meaning that person is not able to accept those assets, either because they themselves have passed away or that they are incapacitated, it creates a situation where you now have to go to court to have someone named and appointed to step up and make sure that that asset can be transferred.
So speaking of the beneficiaries, how can an outdated beneficiary designation create problems for a family later on?
Yes, yes. So the biggest reason that that tends to happen is in a divorce, of course. So we get divorced, the ex is gone, they have no rights to anything. The divorce decree said I got items A, B, C, and the spouse received items E, F, and G, and that's it. It's all split and it's done. But if you forget, those accounts were set up with those financial institutions. And so the
Mm,
responsibility is for you to reach out to that financial institution and let them know because the divorce decree doesn't force those changes. Now, I've seen some where they put in writing in the divorce decree you have to give up those, but even that is not always as enforceable as it seems, right? Because these are private institutions who have rules and they may not necessarily have to abide by your divorce decree. They have to abide by the contract that you have with them, which lists this person as your beneficiary. And so they may very well have to pay it out to that person. The other time that this really becomes an issue is if the person that you've named as the beneficiary is deceased, or as I stated earlier, incapacitated and unable to meet the requirements the financial institution may have. And so they would then need to go through that court process to have, if they're incapacitated, go through the court process. And if they are deceased, then we have to go again to court to have the judge name someone who would now step up in their place.
mm. How do joint ownership or pay on death designations affect what a family is intended to happen after they're gone?
Yeah, so the joint ownership is a way that a lot of people like to try to do their estate planning. It can work. I'm not going to say that it doesn't work at all.
Okay.
It can. If you and I have an account together and I pass away, you now are the sole owner of the account.
Mhm.
That works fine. But if I'm the parent and you're my son, and I put you on there and you decide I'm taking mom's money because
Mhm.
I put you on the account, you can take all my money.
Wow.
That's not the best outcome, I'm sure, for anyone. And so that's the dilemma that you have because we all want to believe that our loved ones are going to do what's best, but that doesn't always help. But it will at least avoid that opportunity for the family or the responsibility, rather, for the family to have to go through a court proceeding to have those assets transferred over. Um,
Mm,
and again, we talked about how most financial institutions will have a pay on death policy, but or a pay on death requirement, but we have to be sure that the people that we're naming are actually able to accept as beneficiaries. And then if we are engaged in having a relationship with a financial institution, then we want to make sure that we actually put a beneficiary down. I can't tell you, I've done planning for many years now. We sit down, we go over. Um, you have the bank account. Do you have a beneficiary listed? Yeah, I got my kid listed as a beneficiary.
mm,
A few years later, dad dies. The kid comes to me. I went to the bank and I couldn't get dad's money. Well, of course you can't get dad's money because guess what? Dad didn't put you down as the beneficiary. So now
mm,
we're having to go through the probate process so that the court can appoint you or some other individual as the administrator, as the personal representative to now go to the bank and say, now that I am the administrator, please pay the assets to the estate. And then now that they've been paid to the estate, then we have to distribute them according to what the state's intestate succession laws were. Or even if there is a will, we can at least distribute them according to the language in the will. But it's a great planning tool in conjunction with the proper plan, right? So you want to make sure that if you have these accounts with financial institutions that are pay on death, like bank accounts, life insurance, all of these things are usually pay on death. You just meet the company's requirements, but you have to be sure that the beneficiaries are valid beneficiaries and that you can take advantage of that pay on death status because they are valid.
Can you walk us through how a plan can fail if a trust is created, but the assets are never, retitled or transferred into it?
Yes, yes, that happens a lot. There are a lot of people who try to do it themselves, which is why we suggest that you don't do that. And because most attorneys are going to, if nothing else, make sure that we transfer the real property into the trust. Although I've had people come in for reviews and I pull up their information on the public records and there's never a transfer. And so the asset is still sitting out there in the individual name, even though there's a trust in place. So, yes, the first thing that you definitely want to do, because it is the largest asset and it is the only asset that is going to require either the trust or a court proceeding to have the asset transferred over. Um, yeah, we make sure that we get that asset put in. Our firm also uses a process that we call funding, and that funding process is where we look at all of those assets that you listed in your inventory when I first talked with you and I said, let's make an inventory of everything that you have. You go through that inventory and you literally write letters. If you can't physically go in, you write a letter. Dear insurance company, I've created a trust. This is who my primary beneficiary is, my son. However, I'd like to add my trust as a contingent beneficiary. So if
Mhm.
something should happen to my son, you can just roll this asset over into my trust and then pay it out according to the terms of my trust. So that's the most important part of the trust itself is the funding, because outside of the funding, you really just have a big binder full of paper that doesn't really mean anything. Now, there's some language that we try to put in the trust to say to the court, we had every intention of moving all of these assets over. We also do what's called a pour over will, which can sometimes encompass some of those things as well. Um, but the proper plan that's going to actually work for you is going to take the time to properly fund. That's the little legal term that we use, but it's going to properly attach all of those assets to your trust.
Mm. Many families have retirement accounts, life insurance, or old bank accounts floating around. What tends to happen when those aren't coordinated with the rest of their plan?
Yes. So that's one of the ways that we end up finding out that we didn't do a very thorough asset inventory. And so that's why getting to know your lawyer and feeling comfortable with your lawyer, that when they ask you questions, that they're not just being nosy and digging into your background. But if I ask you, well, did you work for AT&T all your life or did you work somewhere else? I'm asking that because I need to know if you worked for J.C. Penney's. Are they still around? But if you work for J.C. Penney's, that you may have um, a retirement plan with them as well, not just with the last company that you worked with. And so we'll think through and make sure that there aren't any old assets out there. There are even times I probably should do it more than I do, but we actually go through the unclaimed property process to make sure that we've identified everything that the individual has on the front end. I do it a lot more when I'm doing probate when they haven't planned, but just now I'm even thinking I probably should do it a little bit more on the planning side to make sure that we can catch some of those assets that are old and forgotten about.
I would say I comfortably walked through a J.C. Penney a few days ago, Miss Betsy. So they're still good.
All right, good to know, good to know. I don't shop a lot.
For blended families, or families with the Brady Bunch or different relationships. Why is asset coordination especially important?
Yes, yes, because what we wanna do is make sure that we are taking care of everyone that we felt was important to us, right? You know, this tends to be the most complicated and, how shall I say, intense part of the planning, right? Because if you have acquired what we call them children in love instead of children in laws.
Mhm.
You want to make sure that you account for them if you've raised them in your home. You want to make sure that the children that are no longer in your home are still taken care of. And
Mhm.
so it's important that you put that in writing. I also think that it's important that you have conversations at the time that you're doing your planning to let everyone know what it is that you feel is the best way to distribute your assets so that they're not shocked when the plan comes out when you pass away. Uh,
Mm.
I think that's sometimes what leads to the most conflict because you'll have, say, maybe the older children from the first wife. Well, my dad would have never left me out. But if dad has the conversation ahead of time and says, "Look, you guys are older, you already have your own families, I wanna make sure that I'm taking care of these younger individuals and making sure that they, have at least a starting place. And so sometimes that's a necessary step that needs to be taken. But yes, the intestate laws in most states do not account for children that are not yours. And so if you don't plan, then there will be no way for them to inherit from you. So it's always important to take the time to think about what it is that you would want to leave or provide for children that are not yours, that are in the blended family, before you, well, while you're doing your estate plan.
Mm. For someone listening who isn't sure whether their assets match their documents, what's a simple first step they can take to get things aligned?
Inventory, inventory, inventory. Always, always. One of the things that we provide in our plans is an asset inventory form, and we go over that form at the beginning, at the end, and then we do our review several years later. Because if you don't know what you have, you don't know what you're missing.
Mhm.
And so you don't know whether your documents mirror the assets that you have or not unless you're taking the time to keep up with what it is that you have. You can acquire, you can lose, you know, so it's important to just keep that inventory up to date.
Great. Miss Bessie, thank you so much. All right. Thank you all for listening to When Family Matters Become Legal Matters. If today's conversation was helpful, be sure to like, leave a review, and subscribe to the show so you won't miss a next episode. For more resources or to connect with Ms. Betsy Holton herself and the Holton Law Group team, visit dfwtrustandwills.com. Your family's future is too important to leave to chance, and the right plan can make all the difference. Thank you so much, and we'll see you next time.
Bye bye. Take care.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.